Great. Thank you for joining us for Valuing Real Estate Assets. My name is David Levy from Keen Summit Capital Partners and Summit Investment Management, and I am your moderator. This webinar is part of the Financial Poise webinar series, Ethical Issues in Real Estate-Based Bankruptcies. Slides 7 and 8 provide a summary of the series and episodes. Speaking of slides, you should understand from the get-go that we will not step through the PowerPoint in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation. Keep the PowerPoint handy, however, because I will try to indicate what slides our conversation is touching on as we proceed so you can take notes. Our panelists are Robert Richards, we call him Bob, an attorney from Denton's in Chicago and the chair of the firm's Global Restructuring, Insolvency, and Bankruptcy Practice. Matthew Christensen, an attorney from Johnson May in Boise, Idaho. He's a member of the firm and practices bankruptcy, real estate, civil litigation, and other business matters. Mark Silverman is an attorney from Troutman Pepperlock in Chicago and the firm's commercial mortgage-backed security, also known as CMBS, team leader. Again, I'm David Levy with Keen Summit Capital Partners, a firm that provides real estate services like brokerage, auction, lease restructuring, investment banking, and more for bankruptcies and other special situations. Our sister company is Summit Investment Management that buys all kinds of distressed debt and provides bridge and bankruptcy financing. We appreciate that you're not spending your time and money to attend this webinar to hear infomercials about us. You can read more about us on slides 50 through 53. This webinar is a production of Financial Poise. Sign up for a great free weekly newsletter. Go to financialpoise.com/subscribe. If you are attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand and have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar series, and we will do our best to get you an answer. Special thank you to our sponsors of this episode, Mood Hard Work and Cannabis, Sunburst Digital, the makers of Type to Learn typing app for education, and Max Asset, a simpler, easier, and better way to conduct asset sales. Okay, as the legendary Jackie Gleason used to say, away we go. So today, of course, we're going to have an important conversation about ethics and specifically ethical issues in real estate-based bankruptcy stemming from valuations. Our cast of panelists will speak from different perspectives based on their professional background. Bob Richards from Denton's and Mark Silverman from Troutman Pepperlock both specialize in creditor and lender representation. And Matt Christensen from Johnson May covers a variety of practice areas inside and outside bankruptcy. But for today, he will play the role of an attorney to the debtor. Let's start with a good warm-up and begin with the key question. What are ethics? Bob, please start us off.
Ethics are generally either doing the right thing or at least not doing the wrong thing, and they apply to everyone, not just lawyers, and why sometimes there may be no consequence to being unethical as just a business person. Sometimes there can be. I mean, if you do commit fraud, if you commit fraudulent inducement, there can be legal action against you depending on how unethical the conduct that you do is.
Thanks, Bob. Matt, what do you think?
I agree with what Bob said. I mean, it's doing the right thing, right? It may not be the thing that you may want to do may be legal. And so from a legal standpoint, especially as attorneys, you're telling your clients, look, you're not going to get in trouble for it, but you're also not necessarily doing the right thing. So I think, especially as attorneys, sometimes we forget that at least some people on their business cards put attorney and counselor at law. I think that counselor part matters when it comes to sort of the business ethics.
I like it. Mark, what can you add to this?
Doing the right thing when no one's looking. So this is something that I share with my kids all the time. It's I think that's the way that all of us need to be, because reputation is all that we have in this business, whether you're an attorney or on the business side of things. And so you might be able to get away with something once and feel great about it, and it's probably not going to happen again. So it's that second, third, fourth time that you end up trying to replicate that same kind of dishonest behavior that it really catches up to you. And so it's really, sure, you may be able to get away with it, but you should still be doing the right thing, not only because as lawyers we're required to do so pursuant to the ABA model rules, but also as a business person, it's also just the right thing to do. And my view is that karma can have some significant impacts, and that what goes around comes around. Again, just lots of things that you teach your kids that that ring true in the business sense as well.
I like it. And listen, I'm the non-lawyer in this group. I'm the real estate broker, distressed finance guy. But the anecdote I would give was a fascinating presentation I saw some years ago from Andrew Fastow, the former CFO of Enron. And he held up two items. He held up CFO Magazine that gave him Finance Guy of the Year award. He held up his prison card. And he said, I got both of these things for the same activity. And along the way, our attorney and our bank and our board all not only supported everything I was doing, but told me I was doing a great job. But I knew the cumulative effect of each of these otherwise individual actions was creating a giant fraud. And therefore, not only was it unethical, but it was also illegal. Moving on, getting more specific, let's talk about legal ethics. As Mark alluded to, the American Bar Association, known as the ABA, provides a framework for ethical questions called the model rules. Would love to hear how the model rules influence your individual practices. Matt, please start us off.
So the model rules were, I think the last time they were adopted or really revised was like 2002. So they're getting to be a little older now. Some of the states have updated certain rules since then, but they're just model rules. So every state or local bar association generally has adopted some form of the model rules with some variations here and there between states. So as attorneys, wherever you're licensed or wherever you're practicing, you're governed by the rules that that jurisdiction has adopted. So it's important, if you're practicing in multiple jurisdictions, to understand what nuances there may be between practicing in Idaho versus practicing in Illinois versus practicing in Georgia. And so, but they govern everything the attorneys do. So is it something that a client could pursue a malpractice claim for? No. But it's something they can pursue a bar complaint for, which sometimes is even scarier than a malpractice claim. Malpractice claim, you got to pay money. Bar complaint, you may not have a job anymore to pay money with. So they're important to follow, important to know, important to refer back to from time to time when you have an issue.
Great points. Mark, what can you add to this?
It governs every piece of every interaction that you have, both with your clients and with opposing parties and with the court. You have a duty of candor to the tribunal, so everything that you say to the court needs to be truthful and accurate. And even if there are mistakes, which is something that, again, lawyers don't love to talk about, but lawyers are human and things get said in error, or even briefs get filed that have maybe overreaches in part of your zealous advocacy. Once that's caught, that needs to be reported to the court immediately, and it can be corrected and doesn't necessarily violate the rules depending on the level of whatever misstatement is in the court filing. But it's as Matt said, it's important because this is our lunch card, right? This is how all of us make a living, and the bar complaints can be significant, and they're certainly something that you just want to avoid. You don't ever want to hear from the bar associations on any of this. You don't want to hear from the state licensing authorities, and you want to try to keep your nose clean on all of this. But as I said in the beginning part of this presentation, it's also just the morally correct thing to do. And I think that the easier it is for people to realize that if you're doing the right thing, you're probably complying with the ABA model rules. That's pretty spot on. I remember being in an ethics class in law school where the professor kind of came in and said, we know you have to take this big, scary exam that requires you to learn all of the specific ethic rules, but just do the right thing. And I thought that was awfully glib and seemed unhelpful. But now I'm giving that same advice because it's true. If you're doing the right thing, you're probably going to pass muster under the model rules.
I like it. And Bob, please give us your thoughts.
The only thing I would add is that in a lot of real estate transactions now, it's complicated. I mean, I may be sitting here in Illinois, but I'm lending to properties in 5 states, dealing with 5 different local councils. If I'm foreclosing, I'm probably foreclosing in the states where the properties are located. So it's complicated, and some states have very restrictive rules. Like, Nevada generally wants you to have a Nevada local counsel as part of the proceedings. Others have limits now on how many times you can pro hoc vice into a court. So it's complicated. And for national practice, you really need to know all of the applicable ethical rules, not just my Illinois local ethical rules.
Sure. Well, as discussed, we're going to be talking a lot about the model rules today. There's quite a few of them, but there's a handful that we are going to talk about during this program because they fit in well with some case studies. Those rules include Model Rule 1.1 to 1.3, governing the client-lawyer relationship, rules covering competence, scope of representation, and allocation of authority between client and lawyer in diligence. Rule 3.3 to 3.4 regarding being an advocate, rules covering candor towards the tribunal, fairness to opposing party and counsel. And lastly, Rule 4.1 to 4.3 covering transactions with persons other than clients, involving truthfulness in statements to others, communication with persons already represented by counsel, and dealing with unrepresented persons. Matt, changing gears here, and I'm now up to slide 14. What are valuations used for in bankruptcy, and what might each side's interest be on this topic?
So the valuations are going to come into a case probably the earliest on in the context of a cash collateral motion or an adequate protection motion. Those are typically filed early in the case, and you're looking at the value of the assets in the context of how secure are the secured creditors. Is there an equity cushion that's protecting them in those assets? And so that's where your dispute comes in. You also, as you progress through the case, if there's a sale motion of an asset, the value of the asset is going to be an issue. The court wants to confirm that it's being sold for fair market value in some fashion. In confirmation of a plan, the values of the assets will come into play there. A part of that plan, you've got to describe a hypothetical liquidation, and the values you put on those things in a hypothetical liquidation will matter, sometimes become disputed. In evaluating creditor claims, are they secured creditors? Are they partially secured? Are they oversecured? If they're oversecured, are they oversecured enough that any post-petition fees and expenses can be added to the claim, etc. So there's a whole wide variety, I think, of situations where valuation of the asset may become an issue. The second side of that question was, what are the interests that typical parties have from the debtor side, which is the side I'm most common on. Generally, the debtor wants the property to be as high in value as possible, right? Because then it provides a huge equity cushion to creditors, and they don't need to worry, and we don't need to pay them adequate protection payments, and they're perfectly protected under the plan. And if there's DIP financing, there's still a big enough equity cushion. So, and I think some of that is just most debtors' natural optimistic nature, that the value of things is higher than it may actually be. Creditor side, I think sometimes it's both views. Sometimes the creditor wants the value to be higher because then they can claim they're oversecured and they have a better path to post-petition fees and that sort of thing. But other times they want the value to be lower so they don't have an equity cushion, so they're getting an interest payment or some kind of adequate protection payment. So the creditor's views sometimes vary more than the debtors. And then of course the court's view is, I want to get the right value. And sometimes you'll come in hearings and there'll be an appraiser on this side that says it's worth 10 million, and this other appraiser says the same asset's worth 5 million. And that's when the court's like, okay, well, I'm choosing one or the other, or I'm going right down the middle. And so I think sometimes the judges have the hardest part there in deciding which valuation is actually most correct.
Sure. And Mark, what are the most common ways to value real property?
As Matt alluded to, appraisals used to be kind of the gold standard as something that you would use to get valuations in front of the court. We've been seeing a lot more broker opinion of values, which are things that, David, that I'm sure you provide to many, many, many lenders all over the country. And those tend to be a little bit more reliable from just a presumptive measure of value piece, just given that you're dealing with local brokers or local expertise, and they're basing it on recent sales as opposed to kind of the typical appraisal standards. I still like appraisals. I like to see them. I think that you can give some color to an appraised value by supplementing with the broker's opinion of value. So I think they need to be used in tandem. And as Matt was discussing, if you're in an actual proceeding, if you're in a chapter proceeding of any sort, you need to make sure that you've got strong experts that can really stand behind what value you're putting forward in front of the court on the lender's side of the house, and really get behind the numbers, because it's the numbers are what they are. That everyone can read $30 million on a piece of paper, and that's fine. But what does it really mean, and what is it based on? And are you making some grandiose assumptions based on the last sales pre-COVID? I mean, you can get a little wonky when you're starting to look at comps, and so I think that it's really critical to read through the entirety of the appraisal or broker's opinion of value and really get an understanding as to what the person is doing that's guiding those numbers, because otherwise you can end up with some pretty terrible appraised results. Especially, we've had a lot of bad outcomes in the city of Chicago since a lot of the distressed sales have been so low. Those are now the comps of record. And so you're getting these appraisals and you're scratching your head going, well, yeah, those are the most recent sales, but they're class B, class C office. This is a trophy class, class A on Whacker, and it's significantly more valuable than the class C stuff that just recently sold on LaSalle. So it's definitely something that requires a little bit more of an attuned eye, as opposed to just taking the numbers for what they are on the page. But those are the ways that we typically see folks valuing real estate, is through appraisals and BOVs, and then obviously expert testimony if you're in a proceeding.
Great insight, Mike. I agree with you. It's good to be able to triangulate a little bit because we live in interesting times as it relates to real estate values. And Bob, ultimately, how does the court decide on matters related to real estate value?
I mean, different courts take different approaches. The court's supposed to be a finder of fact based on the evidence presented to it. But some judges are more independent minded. But I'll give you a couple of examples. I mean, a lot of people have appraisals and just think they can introduce them as evidence, but you're really supposed to have the appraiser as a current witness and subject to cross-examination. So you may have a 6-month-old appraisal, but unless they're willing to testify, there can be challenges as to whether that's really valid evidence that a court can consider. I just also had another case where each side had their valuation expert. We deposed each side's valuation expert, and then we brought and presented our valuation expert, and they didn't. But some of the lawyers, tried to argue, and I say, you didn't bring your valuation expert here today. You really can't testify for your valuation expert. So thinking about how to get it into evidence is important. And the final observation I would have is, appraisers, can twist things certain ways. They can weigh certain comparables more than others or whatever. We had another situation where someone was trying to testify that the property was 20 million lower than we thought it was, but then we had an actual bid for 20 million. And, our argument was, if you're talking about comparable values, a bid for this specific property currently pending is the best evidence of what this thing is worth. So it's not only, just appraisal evidence, but if you have recent bids, that may be relevant as well.
Sure. Now let's turn to case studies, focusing in three different areas: declining property value, appreciating property value, and a suspect valuation. Let me just give a shout out to Bob Richards here for his assistance in developing the fact patterns of these cases. So case study number one, declining value. A limited partnership owns a Class C retail mall with a related movie theater and 2 casual dining restaurants in a declining, smaller Midwestern town. The general partner is an individual who has guaranteed up to the mortgage debt, which was obtained at a reduced rate through a government revitalization program. The mall was struggling before COVID and has done much worse. This is back in 2020 and 2021. Several major tenants, including 2 of the anchor tenants, have gone out of business or reduced their space or negotiated for rent reductions. The partners have explored 2 options. First, to revamp the mall, including building senior living apartments in the vacant anchor tenant space. And second, to tear down the mall and sell the land for a new sports complex, and has an as completed valuation for the redevelopment option, as well as a valuation for raw land. It has shared the raw land and redevelopment appraisals with its lender, but has not disclosed to the lender the non-binding offer to buy the land from the sports complex developer. The general partner lacks the funds to implement the redevelopment. One of the redevelopment partners does, but is not convinced on the return on capital and favors the sale for the sports complex, which the limited partner is a co-investor in. The borrower has offered to hand the keys over to the mortgage lender for a release of the general partner's personal guarantee, but the mortgage lender is not excited about owning and operating this money-losing property. Counsel for the borrower has a substantial past due fee owed to it, and also has done work for other projects the general partner is involved with that also have past due legal fees. Counsel is not aware of the sports complex developer offer or the limited partner's interest in the sports complex developer. The mortgage lender has reluctantly filed a judicial foreclosure action and is seeking appointment of a receiver for the property, but is in no hurry to complete the foreclosure process because it does not want to own the property and is concerned there will not be any attractive bids at the foreclosure sale, and that the wealthy limited partner may try to buy the property out of the foreclosure sale at less than half of the outstanding loan amount. What are the ethical issues in play here? Is the borrower acting shady or shrewd? Bob, please give us your thoughts.
Well, clearly in this fact scenario, there's lots of different people with lots of different motivations here. And especially if you're the lawyer on one side or another, you need to really figure out, who you're representing. And it may be multiple people, and there may be some conflicts there between the multiple people in terms of who you're representing. You should not have the fact that your past due fees are owed really influence your advice, even though your finance committee may feel otherwise, because you're supposed to be advising from the client's perspective, not your own or your own firm's perspective. But those are some of the issues that I see in this fact pattern.
Thank you. And Matt, please give us your thoughts.
The first glance I have is similar to Bob's, like who's the actual client? The company versus the general partner, because he obviously does a lot of work for the general partner on other projects too. And so is that additional work for the general partner gonna cause him to temper the advice he would otherwise be giving to the company, who technically I think the company is the client in this situation? The other little piece that kind of jumps out at me is the limited partner that has a investment interest in the sports complex potential buyer, and whether that at this point in the fact pattern probably doesn't really cause much of an issue, but if that sports complex becomes the ultimate buyer, is that connection gonna be something that's gonna cause problems later?
Thanks, Matt. And Mark, lastly, please give us your thoughts on this situation.
Well, as a staunch advocate for creditors and lenders, I always tend to view borrowers as shady instead of shrewd. But that might be my personal bias talking. But here, I do think the concern is that the lender should be brought in and read into whatever potential offers are outstanding, because in some circumstances, the lender may be willing to advance TI, may be willing to advance some expense in order to enhance the property value to be able to sell it. It's not common, but it's certainly something that the lender should know about before just being able to take this back into REO. So I do think there are some issues here, especially debtors counsel. And I know we're getting to this next, but borrowers counsel here has got some significant issues that he or she needs to navigate as well.
Well, I appreciate you teeing up the next set of fact patterns. What if counsel has heard rumors about the sports complex developer offer from others, but has not asked his client or the limited partner about it yet? What do you think, Mark?
Counsel's got to ask if counsel's heard anything kind of through the grapevine and doesn't feel that the client is being truthful or honest with respect to the answers that are being given and advocated for. The attorney has a duty to ask the client and get to the bottom of that prior to taking any other action or making other statements to the court or to the other side. Burying your head in the sand is not one of the ABA model rules that I'm familiar with. So if the attorney has even a scintilla of a belief that something is going on, you got to ask. We're not criminal lawyers that don't want to ask questions we don't want to know the answers to, because then it presents us with ethical issues. We're on the civil and business side of things, and we need to know these things prior to making certain representations to the court.
Thanks, Mark. Matt, what is your view of this situation?
I want to go back to one thing Mark kind of touched on, and that's the communication with the lender and bringing the lender into the loop on things. So I mean, even in representing debtors, I try and emphasize to people, look, when things start going downhill, that's not the time to stop talking to your lender, right? I mean, you'll get a much better response and a much more willingness to work with you, whether it's a sale to a sports complex person, whether it's additional tenant improvements, whatever, if you're keeping that lender in the loop and having that sort of constant communication with them on, look, we're trying, and there's this option we have and this option we have, and we're working towards whatever's going to work best for everybody. So I strongly advocate for nearly 100% of the time having that good open communication with the lender. I think you get better results that way than trying to sort of keep them in the dark and then spring something on them last minute.
Yeah, Matt, sorry to jump in here, David, but Matt, you're the perfect opposing counsel for me. That's exactly what we want. We want our borrowers and borrowers counsel to be over communicative on these issues, because it's certainly easier to get to a consensual resolution, or even a slightly less than consensual resolution, if the parties are actually open and talking. And maybe things don't work, and so we end up litigating anyways, but at least we're doing it it's an arm's length deal. The lender knows what's going on, the borrower knows what the lender's thinking, and everyone is on an even playing field. You may ultimately not get to consensus, but at least everybody's got all the information and all the facts.
Makes sense. Bob, give us your thoughts on this.
Yeah, just a couple add-ons. One, you could have a scenario where, for instance, you as borrower's counsel get asked, well, are there any other offers? And if you think there might be, but you haven't asked, that can put you in a difficult spot. Another thing is you could be in a joint legal business meeting with the lender, and your client says, there's no other offers, you got to do this deal. And that your borrower client may be either making misrepresentation or at least a material omission. And there's rules about that as well. It's not limited to just what the lawyer says, but what the lawyer allows the client to present as well.
And we'll go one more turn of the wheel here and stay with Bob. What if counsel's learned the general partner has taken larger than market management fees and some distributions out of the property the past 2 years? Bob, how does this change things?
Well, I mean, if I represent the project, one thing I have to consider is the project insolvent and who's my duty to. Because if it truly is insolvent, at least in Delaware and some other states, the duty runs primarily to the creditors, not to the equity holders that I do other deals for. And I think the creditors would, want to know that, there may be a chance to recover some money that's been sucked out of the project from my clients on other projects. So it puts me in a difficult situation. But, if it is insolvent, I really do need to think about just the creditor's interest and not the GP's interest.
Thanks, Mark. What do you think?
Fraudulent transfers, fraudulent transfers, fraudulent transfers. Let's go get that money. That's what I think. But from an ethical standpoint, this is, again, very much on the scale of shady. And if you're making distributions when a company is going gangbusters and healthy and everything is going right, and you're refinancing and paying off prior debt and you're making distributions to all of your investors, that's how this is supposed to work. And so everything is fine and this is normal. But as Bob said, if you're even teetering on the balance of insolvency, or perhaps you're just not going to pay debt service to your lender client, and you're making all these distributions of any free cash, you've got some significant legal issues on top of ethical issues if you're advising your client to do this.
Sure. Matt, anything to add?
I just emphasize what Bob said. I mean, it's a hard situation for the attorney. I'm assuming that the attorney didn't know that the distributions were happening, or that the market fees were over market, or excuse me, the management fees were over market, and so it's sort of sprung on them by the GP. Is like, oh, by the way, I did this. Then you have a hard conversation you got to have with that GP, saying, well, look, on behalf of the company, you're going to get sued, and you're going to have to turn over a lot of that stuff. And then whether the attorney ends up being the party actually pursuing that adversary case, or whether you get a trustee or a plan administrator or something to do that, so you can at least try to preserve whatever relationship you have with that GP. It's a thorny issue.
Thanks, Matt. Mark, let's go back to the model rules. Please give us some thoughts on how Rule 1.3 diligence client-lawyer relationship and Rule 4.1 truthfulness in statements to others would apply to this case study.
Absolutely, David. So the client-lawyer relationship is Rule 1.3, which is a lawyer shall act with reasonable diligence and promptness in representing a client. This is true across all of us. So whether you're on the creditor side or the debtor side here. So I think back to our hypothetical, if you hear some information surrounding the potential that there's other offers that are outstanding under 1.3, you arguably have a duty to raise that with your client and at least investigate it. The same is true on the lender side. You need to be thoughtful in pushing cases forward. You need to be thoughtful in making sure that things don't linger. So earlier in the hypothetical, the lender was not super excited about beginning the foreclosure process and installing a receiver, and might be slow pedaling a solution or a resolution on the case. That's okay, and I don't think that you're even skirting close to Rule 1.3 here. But you need to make sure that 2-3 years don't pass where you're doing nothing and things are not being pressed forward, or you'd potentially run afoul of Rule 1.3. So it's really just a matter of diligence and following up and running through the thread with your client as to all of the facts that you're going to then be presenting in front of a court. And this ties in nicely to 4.1, which is truthful commentary and statements to others. So while you have a duty to zealously advocate for your client and negotiate, and you're certainly not going to just say, well, yeah, my client told me that we can give you this number and that's the number. You have to play your hand a little bit closer to the vest, but you can't make affirmative false statements or material omissions that would otherwise change the character of the discussion, the negotiation, or the case. And so here, the question is, if the lawyer knew that there were these outstanding other offers there, would the lawyer have some duty to disclose that to the other side? I'd argue yes, and I'd argue that that's a material piece of this puzzle that would need to get presented. Do I think that if it's irrelevant to the discussions, or if the lender hasn't been asking the right questions, do I think you have to offer that up right away? No, and I think you'd probably be on a jump ball from an ethics standpoint there. but I still would prefer to have that open dialogue. And as Matt and I talked about earlier, I think it makes for a better resolution for all parties to do this. But really, the golden rule is true. It's tell the truth, be honest, be forthright. And if you've got information that is material to the outcome, you can't withhold it. So for example, if you know, another slight tweak on this, but if you know there's some massive tax return that's tax refund that's coming to the property, or that you're going to get some major credit against future taxes because of some tax appeal, and that's going to ultimately go to the borrowing entity and be free cash, gosh, that's an important fact, and that's something that's going to need to get disclosed, and something that you otherwise need to put forward. And we've had situations where you're down the road on a forbearance or a mod or something in the context of a distressed real estate project with a lender, and all of a sudden at the 11th hour you find out, well, shoot, there's several $1 million that are coming back by way of a tax rebate in some material way, and the borrower was expecting to pocket that, and so that materially changes the negotiation. And you scratch your head and you wonder, did the lawyer know about this? Should the lawyer have known about this? And why wasn't it disclosed? And now I do tend to give people the benefit of the doubt. And in those circumstances and situations, it's certainly possible the lawyer had no knowledge because their firm wasn't handling anything with respect to tax appeals or tax rebates. But the client certainly knew about it or should have known about it. And the lawyer, is in questionable grounds here from an ethics standpoint. So again, these two rules are pretty important, and 4.1 treads very closely to duty of candor to the tribunal, which I know we'll talk about later. But it's also important that if you're making a statement to a court and you're signing it with your signature, that you can stand behind that statement and that you've done your underlying diligence tying back to Rule 1.3 to understand that whatever you're putting in a filing, in a public pleading, in a court statement is going to be truthful and accurate to the best of your knowledge and ability, because you're going to be held to a much higher standard as a lawyer than even the business folks would be.
Sure. Let's move now to case study number 2, which is on slide 23. Case study number 2, appreciating property value. 2 real estate developers own an upscale business-oriented hotel acquired through a limited liability company in 2013. The hotel did very well and was cash flow positive through 2019 before COVID required the closure of the hotel for most of 2020. When the hotel reopened in the spring of 2021, occupancy events and room rates have been much lower and only improving slowly over time, with a recent swoon and COVID variant surge led to some meeting cancellations. During the closure, certain trade creditors were stretched and management fees owed to a related party property manager were accrued. The hotel is subject to a $100 million senior mortgage, and more recently in 2019, a $20 million mezzanine loan secured by the developer's equity of the LLC. Both loans are non-recourse, but the mezzanine loan has a bad boy, quote unquote, guarantee if the LLC files for voluntary bankruptcy or encourages an involuntary bankruptcy to be filed against it. The mezzanine lender is also required that the LLC add an independent member who would need to approve any bankruptcy filing by the LLC. The LLC has a 2019 appraisal showing both the senior mortgage and mezzanine loan are all well oversecured with significant equity value to them. There have been no comparable hotel sales in the market since 2018, but there is one pending proposed sale of a competitive hotel nearby, which one of the developers secretly knows is unlikely to close. The senior mortgage has been in default since 2020, and the senior mortgage lender sold its loan to a private equity fund focused on the hotel space. The new lender immediately filed a foreclosure action, and the foreclosure sale is set for tomorrow. The developers are meeting with their attorney, who represents one of the developers regularly and also represents this LLC borrower, to determine whether to file for bankruptcy and whether to propose priming debtor in possession financing from the insiders or mezzanine lender, or to try to obtain forced use of cash collateral over the new senior lender's objection. They have not invited the independent manager to the meeting, but are discussing strategies to threaten or sue or remove the independent manager if he does not authorize the bankruptcy filing in priming DIP or debtor in possession financing. There are a lot of ethical issues in play here. Is the borrower acting shady or shrewd? Matt, please start us off.
Oh, I agree with your statement that there's a lot of ethical issues at play here. The sort of obvious ones to me, first off, is the so-called independent director that the mezzanine lender is wanting to put into place. That's not an unusual step. I think there's been plenty written about what duties that independent director has, who he reports to. He's a director of the LLC. He's not necessarily a representative or owes duties to the lender who put him in place. But at the same time, he may have personal interest in the lender who put him in place, right? This may not be the only company he's an independent director for. So I think that presents some ethical issues for that person, not necessarily the attorney for the company. I think the ethical issue for the attorney for the company is that you're having a company meeting of the directors that you purposely didn't invite that independent director to, and knowingly didn't invite them. And if the attorney knows that he wasn't invited, maybe that's an issue. Can the attorney really adequately represent the company without that independent director there? And there's also some ethics and sort of who is the client issues that are raised by the guarantee that the mezzanine lender put into place. We did have a situation here 10 years ago, maybe, with a similar type of bad boy guarantee on a $250 million loan that nearly everyone in the case agreed bankruptcy was the best option for this LLC, but the owners didn't want to trigger their personal liability on that guarantee by filing a voluntary bankruptcy. And so there were a couple of junior secured creditors enough that filed an involuntary petition. And of course the guarantee said, look, you can't consent in an involuntary case either. So the debtor filed like a 2-page response to the involuntary petition that said, we object and we really don't want this to happen, period. And so the secured creditor who had the guarantee came in and was like, well, obviously they objected, but this basically is getting in there. That case ended up going into bankruptcy and then got converted to a 7 and dismissed. Didn't actually work out. But it's that sort of situation that you're representing the company. Yeah, it may be the very best thing for that company to file a bankruptcy case, but from a personal standpoint for the guarantors, that may be the worst possible thing to happen, because now all of a sudden you've got personal liability on that $20 million mezz loan. So those are a couple of the things. I'll leave a few for Mark and Bob to chime in on too.
Yeah, Mark, please do chime in here.
So with respect to a lot of the real estate deals that we see, a lot of times the guarantor is represented by the same counsel as the borrower. This is a really dangerous place for that attorney to live from an ethics standpoint. Because as Matt just said, the company may be best served and the interest of all of the members of the company may be best served by filing bankruptcy. But the guarantor most certainly isn't, because it would trigger full recourse and full liability for that individual. And so we've had plenty of situations where there's borrower's counsel and there's a pretty loosey-goosey relationship between the borrower's attorney and the guarantor. Maybe they're one and the same, maybe everything is going fine, and so they can advocate effectively for both. But when you get to the situation, you really are potentially pushing the borrower into a chapter proceeding. There needs to be separate counsel for the guarantor. That guarantor's attorney needs to be able to advise the guarantor of the potential recourse implications. The other piece of this puzzle, which is something that we deal with a lot in the CMBS world where I live, is folks aren't familiar with bad boy carve-out or non-recourse carve-out guarantees. And so a lot of times the only deals that the debtor's attorney have dealt with have been traditional bank deals where you have a continuing unlimited guarantee and everything is recourse because you have a continuing unlimited guarantee. And so they threaten and potentially even file for bankruptcy without having fully evaluated the loan documents, the exculpation provisions, and the triggers. And so a lot of times then you have attorneys that are inadvertently springing recourse on their clients, on the guarantors, without really having fully thought through the loan packet, the loan documents, and the implications of what a filing might do. I think that's the exception, not the rule, but we've certainly seen it happen. But those are, yeah, Matt's spot on here.
Great. Bob, please give us your thoughts.
Another aspect I'd touch on is the priming dip financing. It may be that's the best financing available here, but it may also be that other financing, including from the existing lender, may be better. And one of the standards for priming is it, really the only thing that's available. So, representing both the party that may be providing the insider financing and advising the debtor could be a tricky situation as to whether that's really the best financing for this situation.
Sure. Well, let's change up the fact pattern a bit. What if counsel for the borrower learns that the independent manager is a retired executive from the mezz lender? The independent director recently sent an email, demanded that he be notified of all board meetings, formal or informal, and the minimum required 10-day notice under the operating agreement. How does this change things, Mark?
Can I still say shady or shrewd? I'm going shady. Shady, absolutely shady. The issue here is that for an independent director to be valuable and viable here, they need to truly be independent. There's not really a sense of independence here, given that the independent director used to be and probably still has some interest in the mezz lender. And a lot of times, at least for our clients that do mezzanine financing, even if you've retired out of the fund, you may still have some kind of vested financial interest in that fund. And so I'd be curious, just from an ethics standpoint, as to what financial interest the independent director has in the matter writ large. But the other piece of this is the demanding to be notified of all board meetings, formal and informal. That's okay. I don't see any major issues with the independent director having some knowledge as to what's going on at the company level, and I think that's necessary for them to do their job. So it's I guess it's a combo of shady and shrewd, but the internal conflict that independent director would have between the borrowing entity and his former affiliation with the mezz lender is certainly troubling from an ethics standpoint, and whether or not that was disclosed.
Sure, that makes sense. And here is one more. What if the developers recently received an unsolicited all cash, no contingency offer from a major national hotel chain for a price that would pay the project level mortgage and all trade debt and property taxes at the project level in full, and leave excess proceeds to pay about 50% of the mezzanine debt amount, but with no proceeds for future upside for existing equity? The mezz lender is aware of the offer, and the hotel chain is also discussing buying the mezz debt from the mezz lender. The developer wants to file Chapter 11 to try to keep control of the property for its future upside. The mezz debt wants to try to negotiate for a higher price from the hotel chain, but is willing to accept this existing price if the hotel chain won't increase its price. Bob, what do you think about this situation?
Well, one aspect we haven't touched on yet is different legal entities, and the developer may not think of it that way, but the project level owning entity and the mezz level owning entity, which the developer may have most or all of the indirect interests in both. He may think of them as one and the same, but they are two different legal entities. And if you're the attorney representing the legal entity, certainly from the project level entity, taking the offer and paying off all the project level claims is certainly best for those entities. In terms of the mezzanine entity, probably your mezz lender is your only creditor there. And, it sounds like, well, I'd like to get a little more money and much prefer the bird in hand than, play the cards out going forward. And again, talking a little bit about fiduciary duty to creditors, if you're representing both the mezz and the project entities, you really need to think about what are the entities of those creditors and not just what's the developer's hope for a future upside if things further improve.
Sure. Matt, please give us your thoughts.
This one is interesting to me, going back to the guarantee issue. Because the guarantee wouldn't be triggered by the sale of the property. So even though 50% of the mezz debt isn't paid off, it's not that then resides with the guarantors to have to pay it. Whereas if the bankruptcy gets filed to try and maintain control of stuff, that may trigger, or would trigger the guarantee. So that's where I think the attorney for the company has got to sort of weave that thread pretty slickly, in that, look, you guys want to file a bankruptcy case, well, here's the consequence of that, versus agreeing to this sale. And yeah, you might lose some of their future upside, but you're also avoiding a big future downside from a personal standpoint too. And that's an issue that's got to be discussed with them.
Thanks, Matt. And Mark, please give us your point of view.
I'm gonna look at it from an intercreditor standpoint. So if you're taking out the bankruptcy piece, but if you're looking at this from a purely business perspective on the transaction, what does your intercreditor agreement say by and between the senior and mezz? Does the senior secured lender need to give the mezz an opportunity to buy them out at par and allow the mezz to then proceed with that offer? And if the mezz is willing to take that risk on potential future upside, it's maybe something that's worth evaluating just from a business standpoint. So I do think that there's a lot of issues at play, both ethically, business, and legal, in order to evaluate how this is gonna proceed. But if the mezz debt wants to try to negotiate for a higher price from the hotel chain and kind of go down that path, then maybe they should be in the pole position. They should take the risk off the table for the senior secured lender, negotiate a strike price, and step into the shoes, and then proceed forward with the plan on the purchase. And if there's any future upside there, they get to capture that upside. And if not, they take their lumps and they move on. But that's all going to need to be something that's brought to the table so that the parties can actually evaluate it prior to, pushing it into a chapter proceeding.
Thanks, Mark. Bob, let's go back to you to talk about model rules. How do model rule 3.4, fairness to opposing party and counsel, and rule 3.3, candor towards the tribunal, come into play here?
Well, I mean, knowing about the all cash offer, but not necessarily having to, disclose it to all parties, could be problematical because it's a material fact. And again, as we discussed a little bit before, it's not only what you as the lawyer say to the court, but whatever testimony you present, and whether that's misleading or false is also important. So where you have a very material fact, I would certainly encourage the client to allow you to disclose that and consider whether you can present the testimony if they refuse to allow you to do that.
Sure, makes sense. We'll have time for one more case study here. This one we're titling the suspect valuation. Mick and a family trust owns an older commercial office building, which he bought for $4,500,000 with a 50% down. So he financed $2,250,000. Mick acquired this building through a 1031 tax deferred exchange, and rents have increased so steadily he was able to refinance the property and take $1,350,000 out, which he promptly used to buy a dream home on the beach. Mick needed the income to pay the mortgage on his new home, so he stopped paying his bank. Several tenants did not renew their leases in 2020. A big tech company is looking for new office space in the neighborhood, but will not lease space in Mick's building without substantial tenant improvements for tenant collaboration and social activity spaces. The bank is concerned that with their local reputation, did everything they could to work something out, but ultimately had no choice but to pursue foreclosure. Mick has advised the bank of the potential new tenant, but not the tenant improvement requirements, and has claimed his property is worth about $12,500,000 or $100,000 per square foot on grounds that a newer 3,000 square foot fully leased office building nearby just sold for $300,000, which is the same $100 per square foot. To prove he was serious about selling it to pay off the bank, he hired his next door neighbor to sell the property and gave her a 1-year listing agreement. Neither Mick nor the bank have counsel. Are there ethical implications in play here? Is this clever or cagey? Mark, what do you think?
Cagey, I'm gonna stay consistent. Borrowers pull valuations out of thin air all the time. It's fairly commonplace. I think they view the world in a very rosy way. And so that can often be an issue. And I get it. And I understand that here, the borrower is looking at this going, well, I've got a tenant. The tenant's going to come in and it's going to make my property more leased up and it's going to look great for a potential future lender. And this is all good. But we got to spend a bunch of money in order to get the space up to snuff for the tech company to come in. That's a material difference. That could be millions of dollars in, in TI expenses that need to get paid or advanced by the lender. Lender may not be willing to do so. And so really your values are much lower. Also, the comp isn't really a comp. So it's a 3,000 square foot space that's fully leased is very different than the situation that the borrower is dealing with. So it's a frustrating situation. Also, having the borrower 1031 this and then take out $1.3 million on a separate non-collateral beach property. There's some potential implications there and potential shady operations by this borrower. One of the important pieces here also, and I'll let the others speak to this as well, is that this borrower is not represented by counsel. And so you have some concerns here from the lawyer side, because at some point you're going to be communicating with an unrepresented person. And then on the business side of things, again, the person's not getting great advice, they're getting no advice. And so they're really freelancing as far as putting these valuations in place and presenting this information to the lender. And so I think that's going to pose a substantial set of issues for anyone that's dealing with this even down the road, or when this person decides to get wise and engage counsel. A lot of bad may have already been done.
Thanks, Mark. And Matt, what's your perspective on this case?
I want to know what kind of broker the next door neighbor is, right? If it's a residential broker, then I don't know that he's really proving how serious he is about trying to sell that office building. Now, maybe his neighbor is like the highest office building broker in the state, and it's not even a big issue. But just the way that's worded makes me really suspect that that's who it is. And so I think that's an issue, is he's not only using a really suspect comp for what his valuation is, he's basically arguing his property's tripled in value since he originally bought it, even though it's older. So that's an issue to me. I think the lack of counsel is an issue. It does say him and a family trust own the property, so maybe there's counsel for the trust, but not necessarily for him personally. But that just creates the same issue we've talked about before. Who's the actual client for that attorney?
Sure.
So,
Bob, please give us your take.
Yeah, I mean, I know we're getting towards the top of the hour, but I'll add a couple of observations. One is, as the lender's counsel, I'd be much more comfortable dealing with a borrower's counsel than the borrower pro se. And basically every conversation I end up having with the borrower, I'm going to say, I don't represent you. You should get your own counsel. There are legal issues here. I can't advise you on them because I represent the lender. But it's not only uncomfortable for the borrower because he's not getting the legal input that he should be getting, but also for the lender because you're not dealing with a lawyer on the other side, and you have to be very careful about what you say to the borrower. And the borrower may just be trying to save money on fees or whatever, but that's not a good sign either.
Sure. And we are starting to run short on time, so let's do this. I'm going to go through the next two fact patterns and ask just one of the panels to give a quick response. If we change it and we say first for an assumption that the big tech company itself is rumored to be in financial trouble and now has its stock recently delisted from NASDAQ. Mick has not heard from the big tech company in 2 months. How does this change things? Bob, how would this change things?
Well, some things are public. I mean, anyone could look at the NASDAQ listing. There's probably articles on there on, big tech company had layoffs. So I don't feel like I necessarily, need to tell the other side about something that they could read about on Bloomberg or in the paper. The fact that the big tech industry, seems to be less interested in being our tenant, and may not be interested in expanding new space generally. That is something only I know, and probably isn't in a press article. So, I kind of view those two facts as somewhat different because one anyone could look up, and another only I know.
Thanks, Bob. And Matt, how would you react if Mick has not formally retained a counsel for this matter? He has been informally consulting with a neighbor about the situation, who's primarily an employment lawyer. Does this change your view of the situation at all?
It doesn't necessarily change my view of anything that Mick has done. It does raise a whole lot of questions about what an employment lawyer is doing, advising him on real estate issues, banking issues, potentially bankruptcy related things. That lawyer should know enough to tell him, look, I don't know anything about these fields. Go talk to this guy. And so Mick's going to ask questions of whoever he knows, including his neighbor, the real estate broker. And so the attorney needs to recognize the limits of what him or her can do.
Thanks, Matt. And so we can hit just one more topic, the all-important model rules. Please discuss how model rule 4.1, truthfulness and statements to others, and model rule 4.3, dealing with unrepresented persons, might apply to this case. Just need a quick answer. It's going to run out of time. Yeah,
so Mark already kind of talked about 4.1 and truthfulness. Basically, don't make false statements if you know they're false. Now, there's times where as attorneys we may say something that turns out not to be true. That's not an ethics violation, because at the time I said it, it was based on facts that I thought were true. So don't make false statements you know are false. 4.3, I think, is what kicks in here more, because Mick is an unrepresented party. If let's say I'm the attorney for the lender and he's calling me wanting to talk, I've got to disclose to him, look, dude, I don't represent you. I represent the lender. I have duties to them. I'm not looking out for your best interest. I'm looking out for their best interest, and make sure that party understands that you are not their counsel, and that they need to get counsel and talk to their own advocate.
Thanks, Matt. Well, to the audience, I will mention, I advance to slide 34. This presentation is still chocked full of content. We've got a whole section on some notable valuation statute and case studies, and we have provided the long text of all the various model rules that we discussed today. And so with that, because we have to keep to a certain time limit, this will conclude our webinar. I thank you for joining for yet another entertaining and educational production of Financial Poise. I thank our panelists, Matt Christensen, Bob Richards, and Mark Silverman, and encourage everyone to look for Financial Poise webinars wherever better continuing education webinars are sold. Thanks, everyone. That concludes the program.